Hi, good afternoon, and welcome to all of our followers here on Facebook, Instagram, YouTube. We're all today here gathered to be able to answer some questions regarding visas, any questions you may have regarding immigration processes. We're going to be receiving questions live as well, so type in your questions as you have them. And to my right is Mr. Brito.
Hi, how are you?
And he is the managing partner here at Beltran, Brito, Casimir. And Gil, let's go ahead and begin.
Sure.
We have our first question. We had received some questions earlier from Abby. I have applied for the marriage-based green card. It's been a year and I'm still waiting for my interview. What's taking so long?
So there's going to be two ways to apply for this marriage-based green card. There's going to be a consular way of applying for it. That means if this individual is outside of the U.S., his spouse is in the U.S., they're filing an I-130 petition. The I-130 petition is going to be pending some time here. After that time, it's going to go ahead, eventually be approved. National Visa Center is going to go ahead and be in touch with them and go through this process through the National Visa Center. That's going to be upwards of roughly about a year plus currently. If it is a U.S. citizen petitioning the individual. In his case particularly, it's a marriage-based green card. Not too sure if it's a United States citizen doing the petition, that is an immediate relative petition, or if it's a green card holder spouse doing the petition. If it's a green card holder spouse, get ready for 2 years plus. Easily, easy. It's going to be 2 years plus that process. Right. If it's going to be a United States citizen, it's going to be hopefully much quicker. If the individuals are here in the United States and it is a green card holder spouse, it is very important for that individual to also have legal status parallel to this I-130 petition.
While your process is pending.
While the process is pending. Until the green card application, the I-130 application is approved and there is a visa number available. That is called the category F28 in the family charts. If you're looking at the visa bulletin, the F28, just to give you a quick example, it's actually quite favorable right now. And if we look at the visa bulletin, F2A, currently they're processing November 8th, 2016 cases. What does that mean? That means if you filed your I-130 petition November 8th, 2016, or before, you are now able to apply for your adjustment of status. But let's assume his question is, he's in the U.S., he married a United States citizen, and they filed the application, and it's been pending over a year. They're taking, up until the interview, roughly between 18 to 24 months. It depends how long that particular region is. For example, what the wait time for that region. What do I mean by that? Over here in Miami, where we're at the Miami USCIS office, we're seeing approximately 18 to 24 months for an interview based on marriage. If you're in the New York office, it's probably taking roughly about a year. If you're in the LA office, it's looking roughly about 8 months to a year for that interview. What's happened? Why are there now delays for these interviews? There's now delays because now all green cards do require an interview. Yours happens to be marriage, but there's employment green cards. There's green cards based on company sponsorship. There's green cards based on extraordinary ability. There's green cards based on investment. Okay, so there's a multitude of green cards now that require them to have interviews. Okay, so realistically, it's been a year. Get ready that could be anywhere for another 6 months to 12 months before you have the interview.
And related, Gil, we have a question that's very similar to that. You touched it a bit, which is essentially, can this process for a marriage-based be done abroad? And one important point simply to that point is essentially, if it's going to be done abroad, you have to be able to demonstrate that you and your U.S. citizen spouse have an intention to come back and live in the United States.
There should be ties. Yeah, there should be ties. There should be future ties. There's a lot. So there's one of the main requirements is an affidavit of support. The affidavit of support requirement means that this individual that you are going to become financially responsible for the beneficiary, for your spouse in our specific example. And you need to demonstrate that you either have sufficient funds or that you have work. Where's the work? Not outside the U.S. It has to be work within the U.S. Okay? You need to demonstrate other ties that you have the intention of actually coming and living here in the future with your spouse, because the point of typical family immigration law is family reunification. So the idea is that both of you are going to come here to live in the U.S. in the future. Okay.
Correct. Our next question, Gil, we have Ahmed. I did an interview for an I-45. We don't know if it's employment or family. Essentially, the officer told me he would be responding in a couple of weeks. It's been about 2 months, no answer.
Sure.
What should this individual do?
So don't worry, 2 months. When we're talking immigration terms, 2 months is, like you said, 2 weeks, maybe. Maybe even a week, and that's the truth. The reality is that they're backed up, and since they are backed up and there's a lot of cases, my suggestion is to give it 120 days. Okay, so 120 days is pretty much what I'll typically see in a response there. If it has been more than 120 days, then you make an info pass appointment. You can do this through the USCIS website, uscis.gov. Go in there, they'll have a section that says make an appointment. Click here, info pass. It'll take you to the info pass website. You're going to pick your office, which is going to via the zip code. You put in the zip code, they'll tell you the options of offices. It should be the office you had the interview at. Okay. After that, you're going to go ahead and elect a date and time. Take your immigration paperwork with you. Take your I-45 receipt. Take all your information. Take the appointment notice with you that day, and go in and have specific dates. Say, I attended an interview this date. The officer told me everything was fine. Could I find out what's the current process right now? When am I going to have an approval? When can my green card be issued? And just go about it that way. You're not going to get in trouble by going to an info pass. It is fairly a very casual thing to do. It's much more casual than the actual immigration interview. Many times, what I've seen at info pass, we're actually quite successful with info pass, is they will actually go to the back. Maybe if that officer that interviewed you that day is free, they'll actually come out. They'll talk to you and they'll say, oh, thank you so much. Yes, this is what's happening. You'll hear from me within the next 30 days. I think it's a great way to go ahead and just like, hey, remember me? You told me everything was fine, and I just want to get something done with my case. Don't be surprised if you need to do multiple info passes. And again, don't be afraid of doing it. Go ahead, do as many info passes as you need to. I would say split them up, do it every 30 days until you get a response.
Perfect. Okay, this is a great question. FBC asks, what are the actions, responsibilities, and consequences of a sponsor in a perm process? So sponsor being the sponsoring company that's requesting you for the perm process.
So perm process is when a company is sponsoring an individual for the purposes of fulfilling typically a position within their company, a bona fide job offer. The company is going to need to demonstrate that they have the ability to pay the proffered salary. Who determines that ability to pay? It's going to go ahead and be determined by who determines the salary. Excuse me. It's going to be the Department of Labor. You're going to file what's called a prevailing wage determination. Prevailing wage determination is going to take approximately 4 months or so to come back, and that is going to be the salary. The company needs to be able to cover that salary in the future, be able to demonstrate it with tax returns, be able to demonstrate it potentially with bank statements, a profit and loss statement, maybe even audited financial statements, and assets possibly an asset argument demonstrating that they do have the ability to pay the salary. So the company, it's really the company's process. It does not really have to do very much with the foreign national, and they need to really demonstrate that they have done all the necessary recruitment steps through the perm process to make it a bona fide process. Like, they really put in the ads. They really interviewed individuals. They were able to disqualify or not disqualify other individuals. Maybe there is actually somebody more qualified than the foreign national that's being quote unquote sponsored for this petition. So they need to go ahead and make sure the process is done properly. It is obviously some work that the company does have to do during that process, but if it is done properly, obviously it is one of the primary ways that professionals particularly obtain green cards here in the future.
Certainly.
We have a question. Okay, so we have another question.
This is regarding basically the risk regarding the Cuban adjustment and a spouse of a U.S. citizen spouse with a Cuban individual.
The risk of a spouse of a Cuban for Cuban Adjustment Act, CAA. So I'm the spouse of a Cuban Adjustment applicant. Right. Can I also apply for a green card based on Cuban Adjustment? Yes, you can if you're married. Okay, this is very important. So this could be there's going to be two options here. My Cuban spouse already has their green card. Okay, it is very important that they actually adjusted their status through the Cuban Adjustment Act. How do you know this? You look at their green card. If you look at the green card, there will be different codes for green cards. A green card usually has name, date of birth, I've been a resident since date, and then it'll have a category, a code. For Cuban Adjustment, it is CU6 for the principal. Okay, if you're marrying a Cuban, for example, that is a green card holder, their green card needs to say that code, CU6, for you to be able to be conferred a Cuban Adjustment green card in the future. When are you able and eligible to apply for that? After you've been physically present within the United States for 1 year and 1 day. You are not filing an I-130 petition. You are direct filing an I-45 petition. It is a direct green card application based on the Cuban Adjustment Act. It is not a marriage, family-based category. This is not the green card holder category of F2A petitioning a spouse. It is Cuban Adjustment. What are the risks involved? You have to actually be married and continue to be married with this individual. It obviously needs to be a bona fide marriage, and you need to be able to demonstrate that you guys are truthfully and actually married. The good news is, very much unlike when you marry a United States citizen, when it's a Cuban Adjustment Act, you're going to get, regardless, a 10-year green card. If you've been married less than 2 years or more than 2 years at the time of the interview, you will be receiving a 10-year green card. Something that's very particular and interesting about the Cuban Adjustment Act is there is no financial component. There is no necessity for your spouse, your Cuban green card spouse, to demonstrate the ability to support you financially in the U.S. With a United States citizen, there is the affidavit of support requirement. Right? Okay.
And to that point, you bring up a good point. The affidavit of support requirement doesn't have to be the U.S. spouse that provides the affidavit of support.
Okay, that's great. So let's say the U.S. spouse, not in the Cuban Adjustment setting, in the United States citizen setting, petitioning their spouse. What happens if they're not working? What happens if they're studying? They're studying, or they're just between jobs and they're not currently working. You can have what's called a joint sponsor. And that's going to be somebody that is a green card holder, a United States citizen, obviously has the financial resources, is currently working, and is able to say that they will become financially responsible for you. They do not have to be your family. They're just having, they're willing to sign an affidavit stating that they're willing to support you in the future.
Correct. I think we might have a question over
there. Which is the category for a work authorization for an EB1? That is, if you are filing an I-765 employment authorization request. This is a form, I-765. You're requesting different codes. If I am an EB11 applicant, the code you would put on that form is C9. That is basically, I'm an adjustment of status applicant. If you just have an EB11 pending and you have not filed the I-45, you are not eligible for employment authorization in the U.S. just with the EB1 I-140 petition. You need to have already filed the I-45 or concurrently with that I-45 filing requesting the employment authorization, the I-765. You put a code. The code that you're going to use is C9.
All right. Our next question is from Leanne. I have a job offer in the U.S. Can I submit directly to the U.S. consulate in my home country? Is that possible?
It depends what your home country is. There's a couple of situations like Australia, like Chile, for example, like Singapore, where I could file a work visa directly at the consulate. Typically, however, the process is you're actually not filing anything. A company is petitioning for you. That's going to be an H-1B visa. Probably. That could be maybe an L1 visa as well. There's different work visas. You need to consult with your company, and really the company should be consulting with Immigration Counsel on what's the best strategy. There's a lot of different visa options. It depends particularly what country you're from. If you're Mexican, Canadian, there's NAFTA. With NAFTA, you have what's called the TN visa. These are visas you apply for directly at the consulate as well. So what is the difference, Stephanie, between a visa category that that I must apply with USCIS, and there's others that it's not compulsory, you do not actually have to file with USCIS, you could actually file for it directly at the U.S. consulate without going through USCIS. The main distinction is if there is a treaty involved. So if there is a treaty between the U.S. and that country, treaty visas are visas you're able to apply for directly at a U.S. consulate versus having to go through USCIS. By the way, you can also go through USCIS if you're currently within the U.S., But if you're outside, you are able to apply it directly. So I would suggest maybe, drop us a line, make a consultation, go ahead and set an appointment, make an appointment. We could have a consultation.
Wonderful.
Okay.
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 Next question. We essentially have questions regarding the EB-5. How long is an EB-5 process taking? So I guess let's review a little bit of the EB-5 generally first. So the EB-5 is an investor visa, which is available for individuals who this path will eventually lead to permanent residency in the United States. It's an individual who is going to invest between $500,000 or possibly $1 million, depending on the project. It's very specific to projects. And how long is this process taking? What is the process? I
guess we're seeing about 12 to 20 months, even though I saw a couple recently that was 11 months range. So think of it's called the I-526 petition. This is a petition like any other petition. There's I-130 petitions for spouses. There's I-140 petitions for companies and for extraordinary ability. And there's I-526 for immigrant investors. Okay? This is where you're establishing with USCIS that you have, many people think that this has to do, Stephanie, with an amount of investment of money that you're making in the U.S. It actually, that's just one of the requirements.
Correct. It's more really job creation.
It is about job creation. Your investment typically is going to have to demonstrate that 10 direct or indirect jobs were created. It's about the job creation requirement, not so much about that. So this petition is what USCIS is going to take quite a bit of time on. Look, these I-526 petitions are easily about this big, okay? You have to literally put them in a special box, okay? And you need to usually take them directly to FedEx, okay? And the reality is that, they're taking anywhere between 12 to 20 months for that to be approved. Does that mean I have a green card? No. That means now they've approved the petition. If there's a visa number available, you could file, if you're in the U.S., stage 2. That's going to be the I-45 and the adjustment of status, or you're going to do green card immigrant visa processing via the U.S. consulate in your home country, which is typically what we see with I-526.
And an important point is what you will be receiving is in fact a conditional green card, and those conditions will be taken away later on down the road when you're going to go ahead and file in order to demonstrate that this job creation has continued to be active. You have in fact created those 10 jobs, right?
I mean, and going right in line with that, Stephanie, is this question that says, okay, I don't have $500,000 or $1 million, but I have a little bit of money and I like to invest in the U.S. What can I do?
So there are additional options. You can go ahead and get what's known as a non-immigrant visa. Typically the visa here is going to be an E2 visa. And an E2 visa allows a smaller investment. It's not going to lead to permanent residency, but it will allow you to be in the United States, invest in your business, go ahead and invest your money. Typically it's for 5 years and you could extend it several times. It depends on the country truly, but it is an option.
It depends on the treaty, right? So these are treaty-based.
If you're a part of the treaty country.
If you're a part of the treaty. There's treaties that go back into the 1800s. There's treaties that just started in 1990. There's 2000s treaties, okay? So you got to first look, I would say, the responsible job of the attorney, and that's why it's really important, particularly with an E2 visa. We really suggest working with an attorney on this. And you need to look at the treaty. And sometimes, and it depends the country, maybe they only give you 1 year on an investor visa, and you have to renew it. There's actually a country that you only receive 3 months on an investor visa, and you have to go back every 3 months to demonstrate that the business and the enterprise is active, it's functioning. Typically, it's not an issue to renew it when it's such a small duration of time, but it's just something to keep in mind. What's the amount of money? It depends on the business. There is no threshold. There is no minimum threshold. We've seen the E2 visas with $25,000, $30,000. We've seen them for $500,000. Okay, actually no, I've seen them multi-million E2 visas as well. So what it really comes down to is a simple formula that says, to get this business operational, the consulate or USCIS is going to want to see that 75% of that investment has already been done. For example, if that typical, as an example, restaurant cost $100,000 to get up and running, and you've already invested $75,000, $80,000 into that investment, you've basically already complied with the threshold financial requirement.
The key word there, right? The buzzword is that you've committed this funds. That you've committed these funds in order for this business to grow and go ahead and commence.
One question that kind of goes in line with something I said there, which is, we have this question. We have this question a lot. What is the difference between doing an immigration process with or without a lawyer? Okay, this is obviously you're asking lawyers. You're asking lawyers. I tell people all the time, if it's something simple for them to do, 100% you should do it yourself. And that's something, you'll have a consultation with me. People ask me all the time, N400 applications, I'm applying for U.S. citizen. These are my clients sometimes for years. They want me to do it. I tell them, listen, you really could do this yourself. If you have any issues, I'll review it for you. I'll review the form quickly for you. I'll let you know what the pitfalls are. I'll let you know how you need to put something together. But if I could avoid people wasting money in a process, I definitely recommend it. But I tell you this, if I had to have surgery, I wouldn't do surgery on myself. I want a surgeon to go ahead and perform this medical procedure for me. And that's the truth. I see there's a lot of things that are simple, because things that look simple, people think they actually are simple. And there's a lot of pitfalls in an immigration process. It's really interesting, particularly with marriage cases. I see people try to file marriage cases by themselves frequently. And the issue with a marriage case is that it's not that it's difficult, it's that it has a lot of little steps and a lot of little moving parts. So I'll have a client that tells me, I'll have a consultation with us, and they said, Mr. Brito, we've, unfortunately, USCIS has already rejected the package 3 times and has sent it back to me because they didn't properly review the forms, because they're not providing one thing that they actually need to provide on it. And I would tell you, now more than ever, people have been aware of what's been going on in the news. They've been seeing reports. You know, in September we had a little bit of an immigration shift that says, listen, USCIS reserves the right to not just reject a petition that's improperly filed, they may deny it and keep the filing fee about it, okay, as well. So you're gonna lose some money there. So I'm of the opinion that at the very least you should have a consultation, understand the moving parts, understand the complexities of it in your individual immigration case. You know, and going in line with that, a question that we receive is, you know, what makes us different than other law firms? And what makes us different than other law firms? There's a lot of immigration attorneys out there. I mean, there are, you know, and I think having direct, honest advice, conservative advice in these, what I consider trying times right now, for foreign nationals interested in coming to the U.S. To invest, to work, to change their lives, you know, for many reasons, is I think you should go with people that you can trust. You should go with people that will tell you the truth. One thing I do a lot here. I would say I probably say no to more cases than I say yes to. And I would say that's one of the reasons we're successful throughout the years, is because if we actually have a case, we're really trying to proceed as strongly, as aggressively as we can with that case. And if we don't, I have no issue telling somebody we don't have a case. Okay? I think that's going to wrap it up for us.
Thank you for joining us. You can go ahead and visit us on YouTube. You're going to search Beltran Brito Castlemeyer, and on Instagram and Facebook, you can look at us at Beltran Brito LLP.
And also, we want to wish everybody a happy holidays and a safe holidays. And hopefully we'll be back with some interesting content next year. If you have more questions, if there's a video you would like for us to see, if there's issues that you see out there that are not being covered by other individuals, we'd be happy to cover it for you. Thank you.